housekeeping things here. So we're on the same page since we have some new folks today. Make sure we all know how to participate. So the first thing I want to let you know is the session is being recorded, and we will try to post it online at a later date. The second thing, which I'm sure you've already noticed by now, is you've joined without a video of yourself showing, and you're muted and can't do anything about that. Well, you haven't done anything wrong. That's just the settings for the event today. And you also might think that you're the only one here in attendance with Valerie and I, but I promise you there are others. We're just in an anonymous participation mode, so only Valerie and I are able to see the complete list of people in here with us. So what you're looking at right here is a picture that I've previously taken of your screen, and it may resemble and hopefully does the features that you have access to. We'll be communicating today primarily with the Q&A feature. So if you look at the picture in the top right, there's that Q&A bar and it has a little caret. So you may just have to click on that to expand it. And when some of you joined us today, depending on your device, this probably popped up for you and may very well still be up there right now. Now, if you don't see your Q&A panel, that's all right. At the bottom of my picture, you see what looks like a control panel, and everybody has that. So if you're not familiar, you haven't done this before, you can wiggle your mouse around or poke or touch your screen, depending on your device, and that'll bring up your control panel. So I'm just going to pause for a second and let our new folks just try to find that. Okay, so if you see in my picture, I have that blue button with a square with a question mark in it. That's your Q&A panel button. So you can click on that to bring up your Q&A panel or click on it to take it away. If you don't have that button, you can click on the circle with 3 dots because that's going to expand your options, and then you should be able to select Q&A from there. So I'm just going to pause for another second here, and hopefully folks can find their Q&A panel. I'm sure there'll be some good questions and comments today. All right, so if you look at my picture down at the bottom, it says ask all panelists. That's the default, and that's perfect because your questions will come to both Valerie and I. And then below that, you have the text box. And again, yours may look a little different depending on your device, but you can click or touch in that text box and write your question or comment and then click send. Don't forget to click send or it's just gonna hang out in there. So we'll be taking questions throughout Valerie's presentation. So when something pops in your head, just type it in there and click send, and we'll get to all the appropriate questions and comments that we can in the time that we have. And again, we're in that anonymous participation mode, so only Valerie and I will see your name attached with your question. To everybody else, it's just going to look like a question from nobody, and just be sure to keep that personal identifying information out of your question so we do retain that anonymity here. So we might also throw up a couple polls during the presentation. We'll see what happens. If I do, that'll pop right up on your screen. You can choose to participate if you want, click submit, and then we'll keep it moving. So we hope you have fun with us here today and take advantage of asking questions. If you want to leave at any time, you can click that red X. If you accidentally leave, you can always rejoin by going to that email that initially brought you in here today. All right. So I'd like to thank the sponsors of our University Express program, which is my Department of Senior Services, Blue Cross Blue Shield of Western New York, Excelsior Orthopedics, and Wegmans, because they help make this program possible. And I want to let you know that us at Senior Services are here for you. If you have any questions about programs, benefits, services, or supports, please don't hesitate to give us a call. Our phone number is 858-8526. And without further ado, I will introduce Valerie. Valerie Stanek, CFP and Esquire, is an attorney practicing in the area of wills, trust, estates, and elder law. In addition to practicing law, Valerie is a certified financial planning professional focusing on investments, retirements, and estate and long-term care planning. She lives with her husband and Morky Elfie in their newly emptied nest in Amherst, New York, and we're so lucky to have her here with us today. So Valerie, I'll turn it over to you.
Thank you so much, Katie. Good morning, everybody. This presentation is one that I put together in regards to turning assets over to your children or heirs. The reason that I put this presentation together is because it's a topic that comes up on a regular basis. I get questions. People that I work with, clients, for example, will ask me, gee, my neighbor signed their house over to their child. Is that a good idea? Should I do that? I have people say, well, I put my my children on my checking account jointly? Is that a good idea? So I get those questions all the time. So this is going to be a presentation that talks about the pros and cons of those estate planning strategies that turn over your assets to other people or turn over control of your assets to other people. What we're going to talk about, basically the outline of this presentation, is prioritizing your objectives. You have to talk about that first, because the answer to the question, should I or shouldn't I do a certain thing, is always, it depends. And I apologize for giving you a lawyer response, but it really does depend. And the first thing that it depends on is your objectives. Then we're going to talk about powers of attorney, whether you need one, whether it's a good idea, a bad idea, when it's a good idea, when it's a bad idea. Then we're going to talk about actually transferring an asset to someone else and whether that is a good idea and where there are some cons there as well. We're going to talk about adding someone's name. I say my kid's name, but it's any heir. Should I add a name to my checking account, savings account, to my home? And what are the possible ramifications of doing that? We're also going to talk about life estates. I'm not going to get into that very deeply right at this moment, but later on when we cover that topic, I will. Life estates are a little bit complicated, and they are a good solution to some situations. What about transfer on death accounts? What are they? And what are the pros and cons of a transfer on death account? And again, I'll define that and give you some more information about that in a minute. Then we're going to touch on trusts. I'm not going to go too deeply into trust because I'm afraid that I might put you to sleep. There's nothing that a lawyer loves more than something that is extremely complicated and requires an awful lot of detailed drafting of documents, and that would definitely be a trust. However, trusts are really not as complicated as a lawyer would like to have you think. Even though I am a lawyer, I feel like I can say that. And I'm going to touch on what they are, and again, some of the pros and cons of using a trust. And then I'll just conclude, and anytime during this presentation, you can feel free to ask a question via the questions and answers. And then we'll give you some time at the end if you have some questions as well. One thing that I want to say before I jump right in is that at the end of this presentation, there is contact information for me. I want to let you know that as a courtesy to this program, I am available to speak with you either on the phone or for a half an hour or an hour consultation free of charge, just to provide some answers to questions that you may have and see what you might need to do from there. So let's talk about that first subject, prioritizing your objectives. There are all kinds of objectives that people have when they're doing their estate plans and when they're considering transferring assets to someone other than themselves. First of all, people will say to me, what I really want to do is minimize the delay and expense associated with estate administration. So having somebody probate my will, having somebody distribute my assets, I really want to make that as cost effective and inexpensive as possible. So that's one objective that I hear a lot. Another objective is to prevent conflict among your children or your other heirs. So if I don't want my children squabbling over a particular asset, let's say that Disney stock is going to go to your little Disney princess granddaughter, and you don't want anybody else arguing about that, one way to do that is to make the stock in joint name with that child, or other ways of transferring it to the child. Another objective that you might have is to minimize your taxes, whether that be estate taxes, if you're fortunate enough to have an estate large enough to, and we're talking $10 million or more, large enough to be concerned about estate taxes, or for the rest of us mere mortals, capital gains taxes and income taxes, which are also a concern. Another one of the objectives that you may have is to qualify for certain benefits. One of the benefits that a lot of people are not even aware that they are eligible for are Veterans Administration pension benefits, and there are enhanced benefits for individuals who need some type of what the Veterans Association refers to as aid and assistance. So if you need some type of care with the activities of daily living, for example, you have an aide coming into your home, or you're in an assisted or going into an assisted living facility, you may qualify for enhanced benefits with the VA. However, you have to have under a certain limit in terms of assets in order to qualify. So transferring assets may be something that you would consider. And the question would be, how would you do that? Also, people are looking to make sure that if they are eligible and qualify for Medicaid benefits, that they're not making decisions in transferring assets that might actually make them ineligible for benefits. And finally, and sort of most obviously, one of the prime objectives to make doing this kind of planning is to control who gets your assets. But what a lot of people are not aware is that it really isn't too complicated to also determine when people get your assets. So not only at your death, but you can actually control if, for example, a grandchild is going to receive his or her inheritance only after they graduate from college, or only after they reach the age of 25, or maybe 25% at age 25, and another 25% at age 30, et cetera, et cetera. So you can control in great detail who gets your assets, yes, but also exactly when and under what condition they get them. So let's start with these tools in our toolkit for transferring assets or transferring authority to others in the process of doing your estate planning. So let's start with powers of attorney. Now, this isn't a question of actually transferring an asset. This is more a question of transferring authority to handle your assets. So what is a power of attorney? A power of attorney is a document that gives the authority to someone else to manage your assets while you're living. A power of attorney dies when you do. So power of attorney does not last into the period past your death. Once you pass away, then your will takes over, and the executor of your will is the person who handles your assets. But while you're living, if you become incapacitated, or if for some reason you're unavailable, for example, you're traveling, and something needs to be done of a financial nature, bills need to be paid, a property needs to be sold, assets need to move from one place to another, a power of attorney gives someone else the authority to handle that. There are a couple of types of powers of attorney. One is called a durable power of attorney, and what that means is that the power of attorney takes effect immediately and continues until you revoke it. The other is a springing power of attorney, and what that means is that it only springs into action if and when you become incapacitated and a medical professional deems you to be incapacitated and unable to handle your own finances. The objectives that are addressed by a power of attorney is handling, again, your assets if you're incapacitated or out of town. The question is, and that sounds great, right? That sounds like it solves some problems. However, there are some things that could go wrong. So there are pros and there are, of course, cons. The person that you give authority to, unfortunately, could steal from you. And I say that lightly in this presentation, but it definitely is not a light subject matter. This is a very, very common form of financial elder abuse, is the abuse of a power of attorney. So powers of attorney need to be handled carefully and given out to agents that you absolutely trust, or the power of attorney needs to be limited in some way, and there are various ways of doing that in order to make sure that the agents are not stealing from you. If your agent is a child, for example, the only way you can get your money back if the child moves assets against your will or in ways that you did not intend, is for you or someone on your behalf to actually take that child to court and force them to give that money back. Sometimes that turns out, in fact, often it turns out to be impossible because the money simply is gone. The other problem with the power of attorney is that it sometimes causes disputes between heirs or children of the primary person in the power of attorney. In other words, you, when you set up a power of attorney, might have your children fighting over who gets to control your assets. There are also ways to avoid that. One of the ways to do that is to make your children co-agents under the power of attorney. Another way is to add a monitor, someone who is a third party, to monitor and represent you or the other family members in the event that a power of attorney is being mishandled. So powers of attorney are a tool, but like every other tool, they are tools to be used carefully. Another tool is to simply sign assets over to someone else, literally give it away. Some people will say to me, I think what I want to do is just sign everything over to my children now while I'm living. And then if I were to need nursing care, for example, Medicaid would kick in and take care of me. Again, these tools have sharp edges, and sometimes it's a two-edged sword as well. So some of the objectives that are addressed by gifting, some of the things that you actually can accomplish by gifting, you could avoid probate delays and expenses completely. Gift those assets away right now, and you don't need to worry that after your death, your heirs are going to have to wait before they can receive your assets, and you don't need to worry about it costing a lot of money going through probate. It definitely can help qualify for benefits, but again, careful. And I'll get into the cons and the possible ways that could trip you up in a moment. And you could save on estate taxes. Again, this is only for people who have very significant estates, but gifting assets away is one of the ways that people either reduce or eliminate their estate tax burden. So,
Valerie?
Yes, ma'am.
Oh, we have a question that came through about power of attorney. Is now a good time quickly?
Sure, jump right in.
Okay, so the question is, our daughter remarried and moved. Does she need a new power of attorney document?
I'm assuming that she moved out of state. If she moved out of state, then it's a good idea to do a new power of attorney document, just because the laws in a different state may be different and may have different requirements. So it isn't a bad idea. Having said that, powers of attorney from another state are usually recognized by financial institutions. So for example, if your daughter has a New York State power of attorney and they go to Pennsylvania and they take that power of attorney to a bank, the bank in Pennsylvania will probably honor the power of attorney. The only reason that they wouldn't is if there are some rules about Pennsylvania powers of attorney that aren't being followed in that New York State power of attorney document. And so something specific to Pennsylvania isn't being covered in the document, and that could cause a problem. So I often recommend that if you change states, that you update your power of attorney so that it works in the other state. Just also, if I have a client who is, let's say, is a a snowbird, which I was trying to think of the term, and they live half of the year in Florida, I would recommend that they have two powers of attorney, one that is based on New York State law and one that's based on Florida law. And those are not difficult to obtain. Very often they are a form. You can use a form that the state provides, the State Bar Association provides, and you can generate that power of attorney quite fairly easily. It's pretty straightforward.
Okay.
Anything else?
Thank you.
Okay.
Nope, that's it so far.
All right, very good. Okay, so talking about giving it away, we talked about some of the pros about giving your assets away and some of the things that accomplishes. And that's why people do sometimes give assets away. But what are the things that could go wrong? If you give something away, it is important to understand, and of course this seems obvious, but you really need to think about this before you do it. You actually have given it away. You have lost all legal rights to those assets. So there are people who will say, oh, you know what, I'm just going to put this in my son's name, but we will understand that it's actually for my benefit to use it in the future if I need it for something. Well, unfortunately, if it goes into your son's name, for example, legally, you literally have lost all rights to that asset. There is no recourse. You can't go back and sue your son for that and say, well, I didn't really, because when you give it away, you relinquish all legal rights. If you're gifting away real estate, let's say that you're giving away your house and you're putting your children's name on it, taking your name off it, what might happen is you might, well, lose your STAR exemption. So that tax savings that you get under STAR may very well disappear due to the age and income of whoever you gave that property to. You may also fall into the look-back trap. I refer to this as the look-back trap. You probably, most of you probably know what I'm talking about when I say look-back, but let me describe that to you. If you are gifting assets away, in order to qualify for Medicaid down the road, you have to have done that 5 years before you apply for Medicaid assistance. So that's the look-back period, that 5-year period. So if you need nursing care within 5 years and you have no assets, Medicaid is going to, the Medicaid agent is going to look back in your history, and if they see gifting 3 years ago, for example, they are going to delay for the amount of the gift that you gave away. They will delay the providing benefits to you. So I refer to that as the look-back trap, so you need to be very careful there. You may lose your step-up in basis. Step-up in basis is where you gift something to, or you purchase something, let's say a house. You buy your house for $100,000. 15 years later, it's worth $200,000. And at that point, you gift it away to your children. And then you pass away. Your children are going to have to pay capital gains tax on the $100,000 of growth in the value of your home. If you had not gifted the house away, if instead you had allowed the house to go to your children at your passing as an inheritance, that $100,000 capital gains would not exist, because at your death, the value of the basis in your house is stepped up to the market value of the house on the day you passed away. So the basis would be considered $200,000, and there would be no capital gains tax. That's a very, very significant loss that families take when they gift away their homes or gift away other real estate. So it's something that sometimes is not taken into consideration when homes are gifted away, or other real estate, or for that matter, highly appreciated stocks are gifted away. You may lose that asset to your child's creditors. Let's say that you gift away $100,000 in a savings account or a CD. And let's also say that your child owns a business, and that business is having some rocky times due to COVID-19, for example. And now they're going into debt. The child's creditors can use the money that you thought was safe in their hands if the child is no longer able to pay them back. So that money becomes potentially forfeit to your child's creditors. Your child's ex-spouse may get their hands on that money. There can be an argument that it was a gift from you, and your child can dispute that in court. But if the ex-spouse can show that asset was used as a common asset in the marriage, they may have a claim on it after a divorce. So that's certainly something to be considered. Not only that, but your child's spouse often has access online to your child's assets. And again, that asset can be vulnerable to your son or daughter-in-law. Not to cast aspersions on people's in-laws or their children, but something that needs to be taken into consideration. Also, gifting assets away may subject the gift to gift taxes. This is like the estate tax, not something that needs to be worried about by a lot of us, but the few people who have multi-million-dollar estates do need to be concerned about gift taxes. So maybe gifting it away is not the best strategy for your situation. Maybe it is. Again, we would have to look at each person's situation individually. But what about just putting a child's or an heir's name on something so that it's a joint asset, a joint ownership with you? So let's talk about the pros, the objectives that are addressed by joint ownership. Joint ownership also avoids the delays and expenses of probate. So if you own something jointly with your child and you pass away, that asset goes directly to your child without having to go through probate, and it is your child's immediately upon the passing. So very efficient, very cost effective. Also, both owners have easy access and equal rights to the account. That can be a pro and a con, right? On the one hand, if you put your child's name on an asset so that if you are in a hospital, they can easily pay your bills or handle your assets in other ways. This accomplishes that very efficiently to have them on the account in joint name. But having easy access and equal rights to the account also allows them to access assets that you actually think of as yours. And that may or may not be safe depending on the circumstances surrounding all the people involved. So let's talk a little bit about what could go wrong. I'm sorry about that. You almost had the opportunity to see my little dog, my little Morky, who just jumped up on my lap while I'm sitting here. But fortunately, my daughter rescued me and took the dog away. Sorry about that. So let's talk about putting children's name on an asset. Let's talk about what could go wrong with that. If it's real estate, for example, and you want to mortgage the real estate or to sell it, you need your heirs, whether it's your child or someone else, permission to do that. They need to actually sign off, because once you've given them legal ownership in joint name with you, they now have to approve if you decide to mortgage or sell it. By the way, that doesn't sound like there's much concern there about that, but I have definitely seen in the past clients' children decide that their parents should be in an assisted living facility before the parents think that they should be. And I have seen wrangling over selling a house when the parents didn't want to. Fortunately, if it's a joint name situation, that couldn't happen. But if you gifted the house outright to your children, they could sell it out from under you. Now, in this case, everyone would have to sign. If your name was on it and their name was on it, you would have to sign it, and so would they. A lot of people also add their children to their house, assuming that, or to an account, assuming that half of that account would be considered by Medicaid in the event that you went into a long-term care facility to actually be owned by your child or to your other heir. That is not the case. If you have a joint account, Medicaid assumes that 100% of that joint account is yours if you need care, and you have to use it before Medicaid will kick in and provide any benefits to you. Just like in transferring an asset outright to your heirs, they would lose the step up in basis at the point of your death. In other words, when they sell that asset, they would have to pay capital gains tax on it. Again, you could lose a portion of that asset to the child's creditors. You could actually lose the whole thing to the child's creditors. Your child or your child's ex might take that asset or in some way, basically, if it's an account, for example, they could drain the entire account and walk away with it. They have absolute legal access to do that. And the transfer, again, might be subject to gift taxes if it's a large enough transfer. So a lot of people are very concerned. Oh, go ahead, Katie.
We have a couple questions that have come through, if that's okay.
Sure, go right ahead.
And Valerie, your sound is kind of coming in and out, so I'm not sure if you could just bring your laptop a little closer to you, okay. But that would be helpful. Thank you.
Thank you. I'm sorry.
That's all right. So the first question we have is, what is the yearly PP gifting limit? Is it $13,000?
It is currently $14,000, and that is. Let me explain a little bit about that, because that causes a lot of confusion. You often hear that you can gift up to the limit each year. To each of each of you, if you're a couple, can gift up to $14,000 a year to each of your heirs or each of your beneficiaries without any gift tax ramifications. However, for most of us, there will never be a gift tax ramification at all. Most people are not going to have the $10 million estate that you need in order for gift taxes to start being a problem. It used to be that it was only $1 million or $1.5 million. And so if you gifted away more than that, then gift taxes would become an issue. That number has gotten so much higher that it isn't an issue for most people. So if you were to gift away, instead of $14,000, if you were to gift $100,000 to each of your children, there would be no gift tax due by your children for receiving that money, and no gift tax owed by you for gifting that money. The only thing that you would have to do is, and this would be you, not the recipient of the gift, is include the gift in your on your tax return, so that the IRS could start adding up your gifts and make sure that that the cumulative gift over your lifetime doesn't go over that 10 million plus mark, which again, for most of us, it will not. So I just wanted to clarify that. Anything else, Katie?
Yes, thank you so much. That was helpful. Back to power of attorney, just quickly, if that's all right. A question, can there be several power of attorneys?
There can be, but that is usually when you do that, you are making a very specific power of attorney. So you may have a power of attorney that you have specifically, for example, for your business. So you have somebody who is a business partner or a your business manager of your business, and you give them a limited power of attorney to handle one account on behalf of the business, for example. Or you might use a power of attorney that gives your son or daughter a very specific access and right to use and spend money in a specific account on your behalf. So, if you have several different financial financial situation is complicated enough, I could foresee, having a specific power of attorney for your property manager to handle all of your real estate, something along those lines. So yes, you can, but most people in most situations only have one power of attorney, and they usually, it's very often more of a general power of attorney, but you can make it as limited as you would like.
Thank you. Last one for now, if it's all right, just because it's a follow-up about that power of attorney question with them needing the new document.
Yes.
So the question, the follow-up information is the daughter's name and address has changed since remarrying and moving. Does that necessitate a new document?
No, it just because somebody's the important thing is that the important thing is that the daughter lived where she lived. If she didn't change states, for example, if the daughter lived where she lived at the time that the power of attorney was written. Now, having said that, it will facilitate things with the financial institution if the current address is on the document. So if it's a new power of attorney with the current address, you will have fewer steps when you go to when the person who is the agent on the power of attorney goes to use it at a bank, for example.
Thank you.
All right. So let's talk about life estates. A life estate is a handy tool in the toolbox because what it does is it transfers the ownership of your house. Technically, the majority of the house is owned by your heirs, and you retain what the state deems to be a small sliver of the estate. But the sliver of the estate that you keep, and when I say a life estate, by the way, I'm referring to your home. This is in New York State, it's specifically a strategy that's used to transfer the value of your home. So the sliver of the life estate that you, or the sliver of the property that you keep is the time. It's actually a piece of time, if you will. It's the time from the moment that you sign it over to the moment that you die. So, and the value of that life estate, that's called a life estate, that piece of time between now and your death. And that sliver of time, of course, because you're getting older, the sliver of time will become smaller and smaller. And the value of the property is considered to be owned predominantly by your, for example, children or your other heirs. So why that is helpful, well, let's look at the objectives that are addressed. So you keep the legal right to live there for your whole life. So your children cannot, unlike transferring the asset to them, your children can't evict you and they can't sell the property out from under you. You avoid the probate process because at the moment of your death, that property becomes your heirs' property, becomes the property of the people to whom you have transferred that value, which is referred to as the remainder value when you set up the life estate. You could qualify for benefits sooner because the vast majority of the value of the house is not in your name, even though you have control of the property during your lifetime. You could save on estate taxes if the property is worth enough to be concerned about estate taxes. And one of the beautiful things about this is that basically what you're doing is transferring the property to your children without having that, without worrying about them having that big capital gains hit when they sell the house when you pass away, because the value of the property steps up, the basis in the property steps up at your death, just as if you had kept the property in your own name. So what are the cons involved in doing a life estate? Because it sounds like a pretty good deal. You don't really want to do this if you are imminently going into a nursing home and you want to qualify for Medicaid. Because you need to do the transfer 5 years before you need any type of Medicaid assistance for long-term care purposes. So again, that's that look-back trap. Also, the value of that life estate may be subject to a Medicaid lien. So what am I referring to here? If you don't transfer your house and you own it outright and you need to go into a nursing home, you have no spouse, so it's just you, you're single at the time. And you're in a nursing home, Medicaid is paying Your house is still there because they allow the house to remain your property until you pass away. But then Medicaid puts a lien on the house that you're passing, and they can take up to the full value of the house after you pass away. Well, with a life estate, they can do that, but they can only do it up to the value of the life estate, which, remember what I said in the beginning, the value of the life estate is a small sliver of the value of the house. So for example, instead of Medicaid being able to put a lien on the entire $200,000 value of the house, Medicaid can only put a lien on, let's say, $10,000 or $20,000, because that is the value of the life estate. And in some cases, the Medicaid agent doesn't bother to do that because there is an argument that is sometimes made that the life estate is worth zero when you pass away, because the value of the time of your control of the house has expired when you pass away. So sometimes some Medicaid agents will just let that slide. But even if they don't, the value that they can require your estate to pay back is quite small by comparison to losing the entire value of the house. The value of the life estate remains in the estate for tax purposes. So again, that little sliver, if you owe estate taxes, if you have a very large estate, the value of the life estate, that little sliver, say $20,000 of a $200,000 home, could be subject to estate taxes. And the value of the remainder interest is subject to gift taxes. So if you gifted away your house and the remainder interest, which is, if your life estate interest is $20,000 of your $200,000 house, the remainder interest that you transfer to your heirs is $180,000, right? So the value of that interest could be subject to gift taxes, again, if you have gifted away more than, at this point, it's $10 million. So having said that, life estates are in many cases very valuable tools. Now, they're not always applicable. There are certain circumstances where you can't do them, for example, but under a lot of circumstances, they can be a handy tool. Another very handy tool are transfer on death accounts. A lot of people are not aware that that you can put a beneficiary on virtually any type of financial account. So a brokerage account, a savings account, a checking account, almost all accounts can be set up as a transfer on death account. And all that means is that you're setting it up where you are the owner, or you and your spouse are the owner, and you're not putting your son or daughter or both on the account in joint name. Rather, what you're doing is adding your heirs, or your son or your daughter or both, as beneficiaries on the account. So transfer on death account allows not only your IRAs, your life insurance, your annuities, those types of investments to go directly to your heirs on your death. It also can allow your checking account to go directly to your heirs on your death. And that can be a very useful strategy, because it addresses the following objectives. It avoids the delays and expenses of probate. So again, this is another way to avoid probate. You keep control of those assets during your lifetime. Your heirs, or your children, your beneficiaries, cannot use those assets. They have no access to the assets. Their creditors have no access to the assets during your lifetime. So you keep complete control. And if you've put a transfer on death provision on for example, a stock brokerage account or a mutual fund account, the growth in those stocks or in those mutual funds are stepped up at your death, so that your heirs don't have to pay capital gains taxes. So what could go wrong? nothing much really with transfer on death accounts. The assets are in your estate and count against you for estate tax purposes. The assets also count against you. In other words, they are counted as assets when you apply for any type of government benefits like veterans benefits or Medicaid benefits. So there isn't a lot of protection for, from in a certain way, but in terms of probate, transfer on death accounts are a good tool. So let's move on and talk a little bit about trusts. I am not going to go into full detail about trusts because, as I said in the beginning, I could go on and on, but I will touch very lightly on the points that I have here. So what is a trust? First of all, a trust is very simply a provision that allows you to control what happens to your assets after you die. So unlike a will, what a will is, if it's just a straightforward will, is it says, okay, at my death, these assets are going to these people. If in your will it says, if my grandchildren are a beneficiary and they are still minors, I want this money to be held in a uniform transfer to minor account until the child reaches age 25, that's actually a trust. You now have a trust provision in your will. The trusts are very simple, or can be very simple. They can also be very, very complicated. You can create all kinds of tax advantages. You can create all kinds of gifting opportunities. You can be very specific about under what condition you will allow a beneficiary to receive their inheritance. So trusts allow you to have what lawyers refer to as dead hand control over your assets. A lot of people want to know is, are trusts worth the expense? And the answer to that is trusts vary in expense all the way from nothing, like the first trust that I described as part of your will. There's typically no extra expense to writing a will with a provision for minors in it. There's a lawyer won't typically charge you more for that because it's a very straightforward thing to do. So it depends on how complicated the trust is, what it costs. And if you're thinking of doing a costly, complicated trust, the answer to whether or not it's worth the expense is, what is it saving you? What is it accomplishing for you? So with trusts, because they vary so widely and they're so different one from the other, the answer to are they worth it is, unfortunately, it depends. So that would be a specific conversation depending on your circumstances and what you want the trust to accomplish. There are many types of trusts, but there are two broad categories of trusts. One is revocable and the other is irrevocable. A revocable trust is very flexible. It accomplishes a variety of things. Very often it's set up specifically to avoid probate and to keep your assets private. A will is a public document, a trust is a private document. So if you set up a trust, you keep your wishes more private than if you set up a will. A revocable trust can accomplish that. It can also accomplish passing probate and having assets go directly to heirs. An irrevocable trust has some added benefits. It has added tax benefits. It has added, potentially added tax benefits. It also has added benefits in terms of qualifying for benefits such as veterans benefits and Medicaid. A revocable trust does not. And the reason is that if you can revoke the trust and pull the money back into your ownership, the IRS and Medicaid and other government programs do not consider that you've actually given that asset away. They consider that the asset is still in your hands. So the objectives that are addressed by revocable trusts, again, it avoids the expenses and delay of probate. You keep control of the money during your life and after your death. You can control the timing and the conditions of when your assets are transferred to your heirs. You protect those assets from creditors. So a revocable trust allows you to do all of that. You can also change or end the trust very simply. So what could go wrong? You can lose the step-up in basis in some of the assets that you are passing on through a revocable trust. Your assets will remain in your estate for tax purposes. So those assets may be subject to estate taxes. The asset also remains subject to a Medicaid lien because it's considered by Medicaid to still be yours. There are initial and ongoing trust expenses. They can be more and less burdensome depending on how straightforward the trust is and depending on who your trustee is. So the objectives addressed by irrevocable trusts. It removes assets from your estate for the purpose of estate taxes and for benefits qualification. So as long as you move assets into an irrevocable trust 5 years before you need to use Medicaid for long-term care purposes, that asset is considered to not be yours. And therefore, the asset is not counted as your asset when Medicaid decides whether they're going to provide a benefit to you. That's also true for veterans benefits. It avoids probate. So again, the asset flows right through the trust to your heirs and does not need to go through probate. It doesn't need to go through the court process at your death. So it's much more efficient. Again, you retain or you can maintain detailed control of what happens to your assets, when, under what conditions those assets go to your heirs, and you protect those assets from the creditors of your heirs. You also keep the step-up in basis. So what could go wrong? Well, an irrevocable trust is irrevocable, which basically means that it's difficult to take back the asset. You can, by the way, even though it says irrevocable, if everybody agrees, if the trustee, the heirs, and you, the grantor, all agree in writing that the trust can be broken, then it can. But of course, as soon as you break the trust, any protections that you have from setting up the trust are lost. You may also fall into the look-back trap. As I said, you need to have transferred those assets 5 years before you apply for any type of government benefit. There are initial and ongoing trust expenses. And again, those initial trust expenses involves the cost of setting up the trust. There are trusts that you set up in your will. For another example, in addition to where money goes to minors after your death, another one is who gets your pet and provisions for pet care after your death. That's also a little paragraph in a will that's actually considered a trust. Those are little to no cost at all, those types of little trusts. And all the way up to much more complicated trusts for very wealthy people where you're handling the disposition of a business, for example, can be tens, if not hundreds of thousands of dollars. So before I open it up to questions, I'm just going to finish by saying a quick final word about a couple of these things. First of all, you want to make a personalized plan for what's going to happen to your assets. And you want to base that plan on your objectives. And that often requires talking it through, not only with your family, but also with an attorney who knows what questions to ask in order to figure out what objectives you actually have and what tools in the toolbox can accomplish your objectives. My next point here is that you do absolutely need a will. It's interesting how many assets get discovered after someone passes away. Even if you think that you have everything set up so that nothing is going to pass through a will, it's all going to pass directly to the beneficiaries. It's surprising how often there are assets that actually end up needing to be distributed according to a will. And if you don't have a will, New York State will create one for you. And the way that New York State sets up the will, I'm not going to go into that right now. That's a whole other presentation. But the way New York State sets up your will, or your, what we refer to as your dying intestate, right? It's basically a will by intestacy. So the way that New York State would distribute your assets is very often not what you would have wanted yourself. So a will is a very, very important document, no matter how simple, straightforward, and no matter how small your estate. Healthcare proxy is also very, we talked about a power of attorney, didn't talk about healthcare proxy because it has nothing to do with transferring your assets. But I also encourage you to make sure that you have a healthcare proxy and that it says what you want it to say, because that's the document that passes the authority to someone else to make healthcare decisions for you. Again, you see my contact information on this slide. And I do encourage you, if you have questions or if you would like to sit down and talk, to give me a call, and we can do that. I will not charge you for doing that. And then we can discuss whether you need any of these tools to be pulled out of my toolbox for you. The other thing I want to let you know is if you do decide that you want me to, for example, write a will for you, I will tell you upfront what it's going to cost, and there will be no surprises. And I do not charge people for calling me and asking questions. So you don't get bills that you weren't expecting in the mail. So I just wanted to let you know that. Please feel free to ask any questions that you'd like right now. We have time for doing that.
Perfect. Valerie, we have one question that came through so far, but we also have a couple people who called in. So if you just want to read your phone number and your email address so they have them, that'd be great, please.
Oh, sure. My phone number is 716-913-0509. And my email address, I apologize for this because it's an email address that has those letters that you have to give you all the clear definitions of each of the letters. So my email address is V as in Victor, S as in Sam, T as in Thomas, A as in Apple, N as in Nancy, E as in Edward, K as in Kilo, at E as in Edward, S as in Sam, Q as in question, C as in Charlie, F as in Frank, P as in Paul.com.
Thank you.
Okay.
Okay, so this question is, my financial advisor with brokerage set up TOD, but no mention of life estate. Do I need an attorney to handle this as a separate issue?
Yes, a life estate is something that you should discuss with an attorney before you do it. It may or may not turn out to be a good idea for you, depending on all of the circumstances. But if you want to discuss those circumstances with me or with another attorney, in my case, what I would do then is tell you what it would cost to get that done and what all of the ramifications would be in your circumstances, and then you could decide whether you wanted to do it or not.
Okay, thank you. We can wait maybe another minute or so. If folks have any questions, you want to type it in. If nothing comes through in about a minute, we can just thank Valerie, and there's her contact information. And if you need any other referrals or information, again, don't hesitate to contact us at Senior Services. We're at 858-8526, and I'll just pause to see, and then don't forget to press send so it actually comes to us. I mean, Valerie, that was really wonderful and very thorough.